Hello again, Mr. Chugh. My name is Timmy Miller. I'm one of the multimedia co-directors over here at JURIST, and I'm just so thankful that you could be here and to do this interview here with us today. So we're going to jump right into things. And obviously, you have a really interesting and very diverse background, a lot of different experiences. One thing we're interested in hearing from you is, what was your early law school journey like? What were you envisioning your career to look like while you were in school?
Thanks for having me, Timmy. It's a pleasure being here. Um I think the journey of law for me started much earlier than law school. Father was a lawyer, so I've grown up with the sights and sounds and smell of law around me. Started going to courts when I was still I was 7, 8. I started going to court along with father. It wasn't much of a choice. My father wasn't too well as far as health was concerned, so he always could use another person to help him out with going to the court. So started doing that. There was a time when being brought up in a lawyer's family and always looking at law around you with father advising clients, doing briefs at home, law being discussed. So always, picked up the knack of sort of looking at things in a certain way. I was a very difficult kid, to my parents because of that, because I would argue every proposition. I would tell my parents that you should go, talk to somebody or shout at somebody your own age, because we have such a disparity in terms of power. My livelihood or my pocket money depends on you. So always was like that. uh, at the age of 13, 14, I think, is when father's health took a downturn again. He had a major stroke, because of which his practice came to a grinding halt. That's when I started going to court almost regularly, to somehow put together or conserve his practice, help deal with the existing clients, do drafting whatever he could dictate while he was unwell, type out things, draft petitions, do odd jobs that people can do in courts to make an extra buck, draft affidavits, draft property documents, started designing websites, starting advising people in the neighborhood on law. Started doing all of this in earnest at 13, 14. Had to drop out of school. So I love to say that I've essentially studied at the University of Life, or the School of Hard Knocks. I'm not a Rhodes Scholar. I'm a scholar on the road in that sense. So dropped out of school very, very early on. Did the rest of my schooling from what we call the open school, where you don't have to attend classes. You just read on your own and go sit for an exam. That's how it started. And of course, I needed a law degree to be able to practice law. It was never about whether I want to be a lawyer or not. It was always law for me, whether as a judge or a lawyer. I wanted to be in the profession. Loved how we could sort of make a meaningful difference to people's lives by our understanding of law. I had seen a lot of injustice, powerlessness, poverty, and all those things early on in life. So I understood that I could use law as an instrumentality to sort of correct injustices. So I think I completed my schooling at about 16, 16 and a half, joined the 5-year law school at Jamia Millia Islamia in Delhi. Was very active in legal aid work throughout the 5 years of law school. Always wanted my practice of law to have a social dimension, where I'm giving back, where I'm helping the disadvantaged, the last man and the woman in line, use my knowledge to sort of make justice accessible, because in our country, there are many, many barriers to justice, economic, social, and on many, based on race, gender, class. So wanted to use some of my experiences or my understanding of law to help these people. Very actively did legal aid work, started a free legal helpline that I ran for the entirety of my law school, legal sensitization camps. At some point in my law school, I think it was the penultimate year, where I decided that I would want to be a judge. Uh, the motivation behind wanting to be a judge was part sentimental and part what I really wanted to do. So my dad had also, sort of led a very difficult life. He started as a typist, a stenographer in one of Delhi's trial courts called Tisazari Court, and then went on to do law in the evening, and then sort of became a lawyer. It was his dream to sort of have me start from the very court, but as a judge and not as a stenographer. So wanted to help him realize that dream. Also wanted to, again, make a meaningful difference to people's lives, dispense justice, be a part of the solution and not just the problem. Because there's a lot of injustice around, and we as young people feel that what is it that we can do about it? There is only so many petitions you can file, so many columns that you can write. But as a young judge, you can actually make or dispense justice on a day-to-day basis by decisions such as granting bail to somebody. When somebody is socially disadvantaged, does not have bail money, and if you grant him bail on a personal bond, that can make or break a life. So wanted to be sensitive as a judge, and wanted to help. Also wanted to, because being a student of law, always interested in pushing the frontiers of law. Engaging with nuanced issues of law, wanted to contribute to the evolution of law. So these were the motivations. I think during law school, this is how I thought and started preparing for the judicial services exam in the law school days. Because in India, you just need to have a law degree, and then you can take an exam and you can start off as a trial court judge. So you do not have the requirement of sort of spending 5 years or 10 years at the bar before becoming a trial judge. So you just have to take an exam. It's a difficult exam. So took that exam at the age of 23, almost right after law school, and then joined as a judge. So this was what law meant to me. A part of me always wanted to be a lawyer, but it's just that you can't do both at the same time. I couldn't be a lawyer in the day and moonlight as a judge, which may be possible in some jurisdictions, but not in India. So ended up joining the judicial services at 23. It is quite an experience. Yeah.
Very impressive to have, especially that's a very young age. I'm assuming in India, to immediately right after school become a judge.
Yes, it is. But now with the minimum age requirements being taken off, we have many people who in their mid 20s or late 20s are becoming judges. So which again, there are the upsides and downsides. It's led to a lot of young people come into the judicial services. It's brought in a freshness into the system, and people are motivated, they're idealistic, and they want to be a part of the change. And India's judiciary, has been considered very inefficient in certain ways because of delays, because of the inefficiencies of the system. So a younger, motivated task force of judges has really helped in the last few years, I feel. And yeah.
Excuse me. So in the past, we know that the Indian judiciary has come under some heavy criticisms for different conduct. So knowing that, what was your experience being a 23-year-old judge on the bench? And how have your views of the judiciary, or even of, Indian society at large, how those views started to shift, or have they shifted at all?
Indeed, the situation is very different from how it appears on the outside. The Indian judiciary has faced criticism on multiple counts. Some of them are related to the delays in the system, which are massive. We have, about 35, 40 million cases pending. Out of that, 35 million, 32 million at the trial court level. This has led to, a huge backlog. We have other problems like archaic laws. We have very, very vaguely worded laws. We have, a lot of bureaucracy in how, some cases are decided. So there are other criticisms on account of the appointment of judges and how judges are appointed. There's been a huge tussle in the last few years on whether it's the executive that should appoint judges or judges can appoint themselves. For the longest time in India, the judges of the higher courts, the High Court and the Supreme Court, have essentially appointed themselves through a body called the collegium, with the executive only playing a very secondary role, if at all. So the judiciary has come under criticism for that as well. How can the judiciary appoint itself? And is there a need for an external check and balance? So that's been one major point of criticism. Another criticism is docket exclusion, where some of the entry barriers of coming to the court with a case have led to many people being excluded from access to justice. That's another point of criticism. But just coming back to the question on when I became a part of the judiciary, What is the sort of realization that I had? I first of all, on day one, I think the 23, 24-year-old judge, when I joined, on the first day of my court, I had 150 cases on board. And these are all cases which require a lot of care and attention, and you have to spend time going through the files, looking at what the legal and factual issues are, and in order to be able to do something effective on those cases. But with 150 cases on the board, how do you meaningfully hear the parties? How do you appreciate the law? How do you pass orders? And that wasn't just a problem with my court. It's a problem across India, across courts. We just have too few judges. Our judge per million population ratio is one of the lowest in the world. For the longest time, it was about 15 judges per million. And an ideal number, people say, is about 50 judges per million for the system to be sustainable. So 150 matters on a single day on my board. How do you actually do justice to those matters? The number of judges is less. The work is too much. Again, there are a lot of vacancies. For some reason, the governments across times, and I'm not, with respect to one or the other, across times, governments haven't been able to fulfill the vacancies which are there in the system. Many high courts in the country are operating at 50% of the sanctioned strength. So 50% judges just aren't there. And it's not that we don't have a body of good, competent lawyers who can be taken and made judges. I don't know, maybe just for a lack of will, or it's a concerted attempt by the powers that be across time to sort of keep the judiciary in a place where it's not empowered enough in that sense, or competent or capable enough. So there's understaffing, there are delays, there are problems with too many laws, and sometimes badly worded laws. So legislation has also played a great role, which is what I realized as a judge when I went there, because you'll take up a legislation and you'll find out that it raises more questions than it answers. Vague language, a particular section capable of 5 different interpretations. This leads to more and more litigation. From the trial court, you go to the High Court, then to the Supreme Court, then a review before the Supreme Court, then a curative petition before the very Supreme Court. So endless appeals because of vague laws. So I became more aware of these problems, and I started looking at things a little differently. There are problems, for example, in India, if you look at the body of litigation, about 60% of all litigation has government on one side or the other. So the government is fighting those cases, or the government is defending those cases. Government sometimes is extremely litigious. For a small dispute that the government could amicably settle, for instance, and it's a petty case, for instance, they won't settle. They'll say, we'll go to the court and see how that plays out. So over litigiousness on the part of the government has been one of the reasons that we've been so inefficient, as a system. Because at the end of the day, these decisions on the part of the government are taken by civil servants and bureaucrats who would always want to err on the side of litigation. Because if they do not litigate a cause, questions may be asked on why they did not do that, and they may have an inquiry against them. So this self-preservation, in the bureaucracy has made them fight every case till the very last forum, and that has contributed to delays. There are obviously solutions, and we can talk about what are the different things that one can do about it. But these were the problems that I saw as a young judge. And another problem, which sort of defines judgeship for me, at least, was how some of these laws were extremely colonial in how they were drafted. We've inherited a legacy of very old laws, right from the time of the Britishers, which we've carried forward. Many of these laws are extremely insensitive and draconian even. Just to give you one example, there was a law that says if you're begging or if you are selling something in a train without having an appropriate license, that's an offense under the eyes of law. Now, we've continued laws like that, and we continue under such draconian laws to prosecute young people who do not have a job, who do not have any means of livelihood. They are begging, or they are selling tea, for instance, for 5 rupees in a train, and the police would prosecute them, and the entire state machinery would come and prosecute it like a very, very serious criminal case. So I saw that there are many, many old laws which have not been amended, and it needs a fresh look. I've, in appropriate cases, recommended to the government that you take a fresh look at this. This is totally, incompatible with how we look at fundamental rights, human rights. A person should not be punished for his or her poverty. If we can't provide, for a citizen, we can't blame them if they find out a livelihood themselves. So just these old laws and, the need to amend them was important to me, and tried contributing to that as long as I was there. Yeah.
And it's interesting that you brought up the laws as well. I know that it was Justice D.Y. Chandrachud recently noted that anti-terror law is being misused to quell dissent. So having seen that, is that also a trend that you're currently seeing? Are current Indian criminal laws being misused, and how do we need to start rethinking about those?
That's a great question, Timmy. This is not a recent phenomenon. Criminal laws have been misused to quell or curb dissent for the longest time. I mean, this is actually a colonial legacy that we have, which has been carried on even in independent India. Uh, Free speech or freedom of speech and expression is the lifeblood of a constitutional democracy, right? And that was a vision of the constitution makers too. But there were certain laws pre-independence that got carried forward. For example, the offense of sedition, which is under the Indian Penal Code. Now, the Britishers came up with this law in order to curb nationalistic tendencies, with Indians at that point asking for independence. So, but that law continues even after independence. The law is worded, and this goes to how the government can misuse, or how the government of the day can misuse such a law. The law is worded in an extremely vague fashion again. It says anyone who does something to excite or incite disaffection against the government is said to have committed sedition. It's a serious criminal offense where you can be put behind the bars without bail for a number of days and months, even years. Now, just because the law is so vague, governments across times and across establishments have used it to curb dissent, if somebody is genuinely criticizing the government for its handling of a particular decision, that's also brought in the frame of or in the umbrella of sedition. If so, that's a problem, and the vagueness of the law facilitates that. Now, there are indeed a lot of decisions by the Indian Supreme Court that say that merely criticizing the government, merely saying something which is where you are expressing your dissent with the government decision, is not sedition unless there is a quote unquote direct incitement to violence. Supreme Court has said this. It's been 78 years. The Supreme Court said that. But again, that interpretation of the Supreme Court. So the Supreme Court actually watered down the law. Supreme Court said merely exciting disaffection is not sedition unless you are directly inciting people to pick up arms, directly inciting people to indulge in violence in a violent overthrow of the state. Supreme Court's already said this in Kedarnath's case. But the problem is that decision, or the impact of that decision, has not flowed down or trickled down to the police or to the trial courts in different parts of the country, who are still interpreting the law very, very widely, so as to bring into its fold everything that is uncomfortable to the government of the day. So I think there is a serious need to rethink, draft these laws. I've been a party to some of these discussions. Draft these laws more carefully and fashion them more narrowly on what is criminal and what is not. As students of criminal law, we say that there cannot be any blurred signpost to criminality. The criminal law has to be clear, unambiguous, precise, and it has to tell the citizen what is criminal and what is not, so that the citizen can conduct his or her affairs accordingly. A criminal law which is so vague, so all-encompassing, is not something that may be constitutional. So now there is a challenge pending in the Supreme Court on this ground alone, challenging the constitutionality of sedition laws. So there is a need to carefully reframe it, if, of course, the Supreme Court does not declare it unconstitutional itself, and they are currently hearing that matter. And that's not just a problem of sedition, that's a problem with other anti-terrorism laws in India. Again, what is a terrorist activity? What is a quote unquote unlawful activity? Very, very wide definitions. And ultimately it boils down to the will and unchecked discretion or caprice of the government of the day or the police officer on according to them what is unlawful activity. It may be anything or anyone, right, doing it. So again, those need to be rethought. And another instance of where the Indian Supreme Court has come in is 66A of the IT Act. 66A of the Information Technology Act in India penalized any electronic message that or post that caused annoyance, that caused discomfort. So it was worded as vaguely as that. And many people who had views which were uncomfortable to the government of the day were being prosecuted because their views would cause annoyance, quote unquote. And that's where the Supreme Court came down in Shreya Singhal's case and said that a criminal law cannot be as open-ended and vague as that, and we are holding it to be unconstitutional, and it was struck off from the books. I hope something is done even with respect to sedition and some of these anti-terrorism laws, which are sometimes abused to curb dissent.
And it's interesting that you mentioned the Information Technology Act. So in particular, there are certain platforms, I think in Twitter and WhatsApp amongst them, that are in conflict with this law in terms of data privacy. Compliance with it will violate, data privacy rules. So how do you see conflicts like that resolving? And is there a way to resolve them? How are you seeing this kind of coming together?
Yeah. Great question again. This is essentially, a battle of two competing values or priorities. For instance, the state is always going to argue that we need access to certain information on the ground of, for example, national security. And that's the battle that they're fighting currently with WhatsApp, where WhatsApp claims that we ensure to our users end-to-end encryption, where whatever a user sends is not traceable. Even we don't have access to that, or we don't store it on our servers. But the government, of course, wants access to what is being shared on WhatsApp, and WhatsApp has been pushing back in India. Now, the government of the day, of course, justifies it on the ground of national security, on the ground of trying to prevent offenses. And that's the battle that's being fought in every part of the world, right? On whether the government should have access, or is it something that goes against the fundamental right of privacy of an individual? Again, it's a question of how do you strike that balance? Because if you ask me, yes, a government which has totalitarian tendencies may want to sometimes use surveillance, may sometimes want to use the power in order to maybe prosecute individuals, invade their privacy. But on the other hand, there is a legitimate concern too, in the sense that we've all been looking at the problem of misinformation, where a false inflammatory message originating on WhatsApp may lead to riots, may lead to people not taking the vaccination, or many of the other issues, right? Because and since this anonymity that the platform offers may make people say anything without the slightest regard for correctness, without the slightest regard for consequences. So government does have a concern there in wanting to know where a given message may have originated. And now the question is that the end may be okay, but the means to achieve that end are also very, very important. There needs to be very, very good safeguards on in what cases the government can reach out to WhatsApp and ask for information on what message originated from where, what are the grounds, and those again have to be very, very strict grounds and proved on evidence. For example, you have evidence that a crime has been committed, somebody has shared the morphed obscene picture of a young person on WhatsApp, and you have evidence of that, you may be justified in asking WhatsApp to give you the details, because there is a right to reputation, somebody's life is at stake. For instance, in a terrorism situation, the government may have a right or legitimate interest in knowing where, for instance, a bomb is planted, if that is what you want to discover. So those may be genuine investigative needs. But then again, it has to be carefully fashioned. The grounds need to be laid out with precision. The process, there should be checks and balance on the process. For example, an independent review committee looking at what the government is seeking in a given case and on what grounds. And a judicial oversight, for instance, on the government's power. For example, in one case, if the government is only targeting an individual, who has views uncomfortable to the government, that person should have a redress under the law of going to the court and getting that decision quashed. Similarly, the problem with India, to me, is largely we don't have a data protection law. We don't have a privacy law. The Supreme Court indeed in India has said that right to privacy is a fundamental right that is there with every citizen. But again, that right, how is it to be enforced? That machinery is not there, because we do not have a data protection law. A data protection law has been under immense debate for the longest time, but we don't have anything, for example, on the lines of GDPR in Europe. We don't have such a law. I think when that law comes out, many of these controversies or issues will get closer to resolving them, because a citizen would have an enforceable right of privacy and data protection, which may be enforceable against the government, which may be enforceable against social media websites, and a citizen may be able to protect his or her rights against Twitter. I think that was the second part that you asked me. Again, the government has been in a tussle, but the issue there is slightly different. There, the allegation is that the government is trying to introduce censorship. The government, through the new information technology intermediary rules, is trying to get social media companies, social media platforms to basically censor content. Earlier position in India was, if there is something on Twitter, something on Facebook and Instagram, which is offensive, which is obscene, which is problematic, somebody could go to the court or to the government and get a order for pulling it down. But now under the new regime, the social media websites are themselves under an obligation to take down content in certain situations. And if they don't, then they become liable under the law, as if they were the publishers of that information themselves. And this is both criminal law and civil law. So they lose the protection that an intermediary is entitled to under the law, and they don't have any privilege or immunity. So that's again a battle being fought. Again, my view would be is to just try and find out the right balance between somebody's right to reputation and the right freedom of speech and expression, which is there with the citizen. I think when we get that data protection law that we've been waiting for very long, we'll have some resolution and clarity on some of these issues.
And so also most recently, there was the Pegasus spyware attack. I believe this was information, there was some information released yesterday. So can you highlight some of the threats that are coming in through that, especially when you're considering, the privacy of, journalists, of officials who are very much communicating important information?
So again, to me, this again is an evolving situation. There is a fierce contest on what really the facts are. But broadly on what we see, the government seems to have taken a stand where they say under the law, a government is entitled to intercept conversations under the Information Technology Act, under the Indian Telegraph Act. That's as far as the law is concerned, which is the government stand. Now, some people have argued that the government stand is also very, very ambiguous, where they haven't completely owned or disowned the allegation. And the allegations, no doubt, are extremely serious. Relates to the privacy of the individual, and the government hasn't taken that definite stand on it as of now. But as per the law, they say we have a right to intercept conversations. Now, the law doesn't say what may be the mode of that interception. How do you actually achieve it? Can you use a third-party software and clandestinely install it, or get it installed on the mobile phone or a laptop of an individual and then intercept conversation? Or you have to go to the service provider and technology company and then do it? What are the ways and means? Again, it's a big gray area under the law, whether this is a valid mode, legal way of interception or not. Some people indeed argue that this is something that may qualify as hacking. In India, under the Information Technology Act, if you obtain unauthorized access to somebody's phone or electronic device, and this is illegally done in an unauthorized way without consent, with an intent to do something mischievous, that's an offense. So some people have argued that this is an offense committed by the government of the day. Again, the problem comes up because although we have an overarching right to privacy as citizens of the country declared by the Supreme Court of India, but we don't have a machinery for its enforcement. Because a judgment which declares something as a fundamental right. And mind you, Timmy, for the longest time, the position in India was that a citizen is not entitled to a right to privacy. At least a good body of legal experts believe that as per our constitution, there is no right to privacy. It is only recently, a couple of years back, that the Supreme Court says that you do have a right to privacy. But again, that was a broad declaration. The Supreme Court expected the government of the day to come up with a data privacy law, a data protection law, which again hasn't been brought in. Today, if there was an allegation of the government intercepting conversations, snooping, if we had that law, it could have been investigated, it could have been probed, there would be consequences for it. And at least these people who've been, allegedly spied upon, they could have had redress in the court of law, in that sense. So again, the absence of a law is making things extremely difficult.
Thank you. And obviously an evolving issue, so I'm interested to keep following it and see where it ends up going. So kind of one last thing, I guess, in relation to Indian laws. So there are different personal laws for different religions, for Hindus, for Muslims, Parsis, and Christians. And the Delhi High Court has put forth a case for this implementation of a uniform civil code. So what does that mean? And how will that affect how do you see that interacting with Indian society? And what are the changes you'll see?
That's again a very, very interesting and a difficult question to answer. To me, India is a country of great diversity, in terms of religion, in terms of caste, in terms of many, many other levels. This debate's been there for the longest time. It's not a new debate. When we were deliberating what should be the form our constitution should take, our legal system should take, back in the late 40s and 50s. This was a question before the makers of our constitution and the founding fathers of our nation. And the question was that since we have so much diversity, Hindus, Muslims, Parsis, Jains, all of them would have their own rites and ceremonies. They have their own rituals and customs, and the personal rights, relating to how a marriage is to be solemnized, how a divorce is to be obtained, whether divorce is even possible or not, what is that wife is entitled to under the law as far as maintenance and alimony is concerned, how many times can somebody marry, because you'd be surprised to know before 1955 a Hindu man could marry any number of times. There wasn't a maximum limit of the number of wives he could legally have. It was only in 1955 that we introduced monogamy as a matter of law for a Hindu man. So at that point, there was a great diversity. For example, a Muslim man in certain sects can marry 4 wives at the same time. So there is polygamy there. So at the time when we were making a break from the past and introducing a new legal system, we had this question: should we have one sets of rights and obligations and duties on all the citizens as far as marriage, divorce, property, succession, wills, all of these matters are concerned, or should we let them be governed by their personal laws, which again draw from their religion? For example, in Islamic law, you'll draw from the Holy Quran, or Hindus would draw from their religious documents. At that point, it led to a fierce debate. Some people were in favor of having a uniform law for everyone, regardless of the religion and everything. But at that point, the constitution makers believed that this may not be the right time. There is a lot of diversity in the country. If we fasten a common civil code or a uniform civil code on the citizenry in a top-down manner, that may lead to discontent, that may lead to continuing fissures in the country. That is not how you bring the country together. But they felt that at some point, this is something we need to achieve. So in the constitution, they did not say that state is under a definite duty to introduce a uniform civil code. They said the state shall make endeavors to at some point do a uniform civil code for everyone. Now that was the broad direction to the state, that please keep this philosophy in mind, and at some point please introduce uniformity, because uniformity has a big upside. People know what their rights and obligations are. For example, women in the Muslim community have been disadvantaged for a very long time, where the husband could marry 4 times. There were not defined rights of maintenance, whether a divorced Muslim woman is even entitled to alimony or maintenance from the husband if he's just deserted her and married somebody else. there wasn't clarity on this for the longest time. So having a uniform code based on the values of gender justice, based on the value of human rights was very, very important, but we couldn't do it. And maybe we didn't do it all these years for the right reasons, because we were not able to command the faith and the trust of certain minority communities, you know, because of certain actions, or, you know, there may be multiple reasons for that. We were just not able to command the confidence to get everyone to sit together, have a consensus that we need to have a uniform civil code. Do I feel there is a need for it? The answer is absolutely yes, because it's a matter of gender justice and rights, right? Why should a Muslim woman or a Muslim wife be disadvantaged, or should be given a different treatment under the law than a Hindu wife? And so on. I mean, if they are entitled, the right to equality or the right to gender justice should apply to women or people across religions. That's a given. And sometimes, you know, if a given religion, and I'm not talking about one or the other, if a given religion does mete out harsh or discriminatory treatment to somebody in a given case, then the person should be dealt with a civil, secular, modern law, and maybe not a document that was written 1300 years earlier. So again, changes need to be introduced, but the problem has been that, you know, certain communities, for right or wrong reasons, I would say, you know, for a legitimate reason, has seen every attempt to introduce uniform civil code as an interference with religion, as an interference with and a transgression into how they conduct their lives. So for some reason, we've not been able to command their faith and their trust. And that is the reason uniform civil code could not be introduced for the longest time. You know, so I agree, just to answer the question again, is the idea good in principle? Yes. Would it lead to better gender justice? Yes. Would it lead to, you know, ease to certain vulnerable sections? Yes, they would be able to realize their rights better. But again, this needs consultation, this needs consensus, this needs bringing everyone together, because we are, after all, one country, and we have to, you know, be in this together. But again, do it in a phased manner or do it after wide consultations. It just can't be forced on the citizenry, because they would look at it as a transgression into their personal lives and their religion. And religion, again, to me, is a very, very sensitive issue in India. You know, we don't have a complete wall of separation where religion is one thing and law is the other. Religion is a part of everything that we do. Religion is a part of our life and every part of our life. So needs to be done with delicacy, with sensitiveness, with compassion, and possibly over a phased out manner.
Thank you. And it's always interesting to hear that, because, you know, from the American perspective, right, we've always just kind of assumed there's this wall. But even for us, there are a lot of times where that kind of bleeds over, and, you know, specific representatives have, you know, religious motives. And it's interesting, and it's hard, you know, to always find that consensus. So I'm not sure quite what the path forward is on that specific issue, but it's one that I think a lot of people struggle with, even in America and India. It's interesting, we kind of struggle with the same thing. So moving back towards kind of the idea of education, a lot of our viewers and listeners are going to be law students throughout the world. And so I'm interested to hear from your perspective. So legal education is changing, right? There are the national law universities, and then there are the other schools. How can you enlighten our viewers on how number one, how do these two different units function, and what are the inherent differences between the two, if any?
Legal profession's been fairly established in India for a long time. But national law schools or national universities is a relatively recent phenomenon. In the last, let's say, 20, 25 years, this has come up, which is a short time given how large the arc of our evolution is. So what was the need for having a separate set of law schools called the National Law School or the National Law University? The need was that the existing legal education and the quality of our education was considered insufficient in a lot of ways. And that led to the movement where the Supreme Court got involved, and some of the some academia in the country got involved, and they started the national law universities. So just to put it simply, there are a bunch of law schools, about 10, 15, or 20, who come under the umbrella of national law schools. They have a separate entrance tests, sometimes more than one, which a person wanting to do law has to take. It's a difficult test, very competitive. A lot of people apply every year, and the number of people selected is relatively less. So it's a very competitive and considered a difficult test. So that's for the national law schools. But there are many law schools across the country which are non-national law schools, which may be central universities, which may be private law schools. We have a lot of law schools in India. Those again have their own entrance tests. They have their own way of going about it. Given how difficult it is to get into a national law school, it is considered that those law schools possibly the product is better, or the quality is better, so that the outcomes after college are better. There may be some truth in the fact that since the entrance exam is very difficult, few people make it there. Of course, the quality of legal education there is good. That leads to better placements. That leads to the alumni performing better. But then again, the majority of the country's lawyers come out of non-national law schools. I didn't go to a national law school. I didn't go to one for totally different reasons, that I couldn't afford the fee. And but majority of India goes to non-national law schools. Again, the broad curriculum is the same. The Bar Council of India, which is the head body which controls legal education in India, has a common curriculum for all the law schools. So that's the broad structure on how national law schools and other law schools function. At the end of the day, I think because I've sat as a recruiter, I've sat as a judge, and I've seen young lawyers and law students from across the spectrum. I don't have an inclination in favor of one or the other. I think at the end of the day, it's the individual, the who counts. And if one is meritorious, one sort of finds out a way to navigate the profession. Opportunities, I would say, initially are not equally divided between national law schools and other law schools. Some of, for example, the tier one law firms, the biggest law firms in the country, do sometimes prefer national law school candidates for the opportunities. And we've been trying, of course, for the longest time to have a more inclusive system, more of a level playing field where candidates from across law schools are provided equal or equitable opportunities in terms of placements, in terms of, my personal chamber, we've never gone by what law school do you come from. It's all about the candidate. It's all about how good a lawyer you can be or you are, and how hard you're willing to sort of work. So that's the broad, spectrum of legal education in the country. Yeah.
And so you also have been talking about how you interact with this as well, both as someone who has helped law students find their place, and also taking them into your chambers. So I'm sure you've also engaged with a lot of different mentorship relations with them. So I assume you have a lot to talk about in that regard. Given that you have done a lot of different things. First, you were a judge, but after you resigned, you joined a law firm. So what was that transition like? And what is law firm culture like in India? Because I think we have law firms in America, but do they function the same way? How do they work? And how was that transition for you?
So when I served as a judge for about 3.5 years, joined at 23. Had an opportunity of looking at the system from a number of different perspectives. Was a civil judge, was also a judge on the criminal side. After, many people ask me this question, why the need to come back to the bar? And, to that I say that judgeship was dear to me, but advocacy is dearer. I've always identified more with being a lawyer, the power of a good advocate, your persuasion, cross-examining a difficult witness, convincing a difficult judge, molding a will, getting somebody to believe in your narrative, somebody who's taught not to believe in you. I loved all of that about the practice of law. And, also one thing I must flag, that being a young judge is a lot like being an adult without ever being a child. It's almost like you missed and jumped over the fun years of your life. So judgeship should possibly happen to people at a certain point where you've lived your life and you've seen the diversity of experience. I wanted to do that. I also wanted to do different things in terms of So I do a lot of international arbitration. I do criminal white collar crime trials, internal investigations, corporate litigation. As a young lawyer, I get to do all of that. But sometimes as a young judge, you feel constrained by having to do similar matters and stuff like that. So these were my reasons. I, of course, had the great fortune of joining one of the best law firms in the country, Luthra and Luthra. And I joined the disputes team there. It's a full service law firm, having a litigation practice. Within litigation, there are civil practices, there are criminal practices, there are insolvency litigation, IPR litigation, tax litigation, competition law litigation, antitrust. I joined the core litigation practice where I did criminal law, largely white collar crime defense cases, arbitration, and a number of other things. Great time at the law firm. We got to work on some of the most complex, some of the most high stake and difficult matters in the country. Those matters still go to big law firms, because a big law firm, as you know, has the benefit of bandwidth, has the benefit of a knowledge base, has the benefit of resources. On most complicated financial litigation, you would want to have a full service law firm working on it, because on one matter, you would have an antitrust issue, you would have a market regulator, you would have a stock market regulator looking into it, you would have a local police looking into it, you would have a fraud office looking into the same matter. So you get to bring people together across disciplines who are able to come in and weigh in with their expertise, and you can give the client a holistic solution to the matter. So that's what working in a tier 1 law firm means. Had a great time. There's so much that you learn by working on such complex cases, many of them having an international element. So worked a lot with the lawyers across the world, worked with some of the best minds in the country, the leading senior counsels who we used to brief and work with. Which is equivalent to a Queen's Counsel, in England. Worked with those, so got to learn a lot. And that's and allow me to segue into the second part of your question: how's the law firm culture like in India? So some of the we have very, very big law firms, but the law firm culture in India started in earnest, I think, about 25, 30 years. It's not older than that. Before that, we had firms, but the legal profession was largely dominated by individual practitioners, senior counsels, who are equal to barristers or Queen's Counsel. They dominated the profession in most ways, and we did not have very big firms. But and India was, just to give you a brief context, India was a closed economy. It was a socialist economy where state would own the means of production. There wasn't much foreign investment. The banks, the basic power utilities, the basic infrastructure, everything was a government. So when you did not have foreign investment, you did not have private companies owning, the means of production or having a stake in the growth of the country. There were problems. We've had a GDP growth of 3%, or lesser than that for the longest time. So India didn't grow for the longest time, for the first 50 years of its independence, or 45 years of its independence. But then in 90s, you possibly weren't even born. I was 1 year old or something. India opened up its economy to the world, where many sectors were opened up for foreign investment, which is known as the liberalization of the Indian economy. When that happened in the early 90s, that's where, when a foreign investor came in, a sophisticated corporation coming in, wanted the best legal advice on how to invest in India, how to acquire Indian companies, foreign exchange regulation, mergers and acquisitions, capital markets, all of these, project finance, because there was a lot of investment in infrastructure back then. All of these areas sort of came up for the first time in the 90s. And when you had such complex disputes, you had to deal with foreign law firms, foreign MNCs, that led to people sort of congregating together in the form of firms, so as to be able to give their clients a holistic solution within the umbrella of one single firm. That led to the first few big pan-India law firms in the country. And then again, competition law, insolvency, intellectual property, all these areas sort of came, and the law firm culture grew. Now we have law firms with about 800, 900 lawyers also in India, very, very big law firms with offices across the world. So that's the law firm culture. Law firms have largely in India done either corporate transactional work, or they've acted as solicitors in litigation and disputes matters, where they make a case, strategize, do the filing, do the drafting, and then brief a senior counsel to be the face in the court and to argue the matter in court. So still it's structured more or less like that. We don't have foreign law firms in India. That's not something that's permitted as per the rules. So it is essentially the Indian law firms who work a lot with their counterparts across the world. We don't have foreign law firms per se in India in that sense. Again, our law firms are growing. We are having more and more super specialization departments. For example, there are law firms or departments which are just dealing with artificial intelligence, cryptocurrency, drones, cloud computing. We have law firms with departments on data privacy, insolvency law. So legal profession is still getting more sophisticated as we go along. Of course, there's a lot that needs to be done. For example, internal investigations, data privacy, all of these areas we are starting to grapple with, and there's a long way to go. But that's the law firm culture. As far as billing's concerned, most law firms bill by the hour, the bigger ones at least, again, which is very similar to how it's done elsewhere in the world. But yes, some work on fixed fee quotes. We do not have contingency fee in India. That's another thing that sets us apart. A lawyer or a law firm cannot charge a client on the basis of the outcome of the litigation. So you cannot say, I'll charge you 10% of what you get finally in the court, which may be permissible in other jurisdictions, but in India, it is not. There are concerns on third-party funding in India. There's a body of jurists who believe that third-party funding in India for a litigation, for instance, somebody does not have the means to go to the court and do a high-powered litigation, can take a third-party funding to finance the litigation. That was considered as unethical or improper for the longest time. Again, that's a concept that we are warming up to. We are warming up to international commercial arbitration, and we've come a long way in that sense, but a long way to go as well. Yeah.
Then we have gotten to our last question. So you've seen all of it. You've been a judge, you have been in a firm, and you've also been independent counsel. So I think that this past year has presented a lot of unique challenges, especially with courts moving to a virtual format in order to curb the effects of the pandemic. So as an independent counsel now, what are the challenges that you've witnessed with this? Have there been any benefits to it? And do you see courts moving towards more accessibility with this overall?
Great question, Timmy. Thanks for that. I think the feeling is mixed. On one hand, we are extremely, we're extremely saddened because we've lost a lot of friends, judges, lawyers, because of the pandemic, and judiciary was disproportionately hit also, in a lot of ways because it is considered as an essential commodity, and for the longest time, judges and lawyers had to show up for work, despite the pandemic. And a lot of friends we've lost in that process. And it came to a point where there was a choice: either you save your life, or you look at your livelihood. And at that point, of course, the choice to make was to shut it down and look at it at a later point of time. The courts tried grappling with it. Traditionally, the Indian judiciary has, sorry to say, but not been very technocrat in that sense. We weren't prepared for this. In most of the cases, we didn't have even the soft copies of the files in question. E-filing wasn't something that had been implemented very, very well. Most cases were still, you'll have hard copies of files stored in, big boxes in the court. And we hadn't really woken up to e-filing, e-discovery, online hearings. We hadn't really grasped that. But then again, sometimes it takes a jolt. You can't sort of change wheels on a moving car. So the pandemic brought the car to a halt, and then we had to reimagine everything. And that's how we started doing hearings through video conferencing. But for the most part, in the last 1 year, although some of the courts have grappled really well, where they quickly embraced video conferencing. Some courts, in fact, went to the extent of introducing live streaming on YouTube of the court, which I feel was extraordinary, because live streaming of court proceedings is something that we've been demanding for the very long time, because we thought this would introduce transparency and accountability in the system, also open up the courts of justice to people for them to see how it works. So sunshine is the best disinfectant. So that was one good thing that came out of it, where now the court is possibly accessible to somebody. And India is a big country sitting in the other part of the country, who can just, from the comfort of his or her house, watch court proceedings, see what's happening in their case, and be more connected and aligned to the process as a stakeholder. So that's something good that's come out of it. There are people who could not possibly pursue their matters in the Supreme Court by traveling all the way to the Indian Supreme Court, located in the capital of the country. Now they can agitate their causes by e-filing their cases through the computer, and then attending a hearing through video conferencing, which was totally unimaginable earlier. So that's good. But again, the system, especially at the trial court level, has not been able to come to terms with it, despite the last 1.5 years. For instance, most of the cases at the trial court levels are still stuck because the courts are not able to do effective hearings on VC. They've only been taking the most urgent cases. For example, bail applications, custody applications, urgent injunctions in civil matters. These are the only cases that are being heard at the trial court level. Why is that? Because the courts are not equipped to do full-blown trials through video conferencing. Files running into thousands of pages have not been scanned so far. So you cannot actually argue on trial. And you would understand that the main job of the trial court is to actually conduct a trial, where you receive evidence, there's examination in chief, there's cross-examination, and you see how the trial plays out. None of that's been happening for the last 1.5 years, and a lot of cases are stuck because we've not sort of scanned the files, or totally taken the process. For example, cross-examining a witness on a video conferencing is a huge problem, because number one, we don't have files. Second is the witness sitting in some remote part of the country may not have access to a good internet connection, may not have access to a proper machine. And even if the witness has those things, how do you ensure that the witness is not being tutored by somebody else in the room during a cross-examination? You would not have the benefit of those panoramic cameras everywhere. So these are some very, very grave practical issues that we are facing. Of course, the high courts and other courts are sort of brainstorming on how to resolve these matters. So we hope that gets resolved soon. Another thing that is a bit of a takeaway from all of this is that for law students especially, they now can witness more and more proceedings in different parts of the country by just logging on to certain video conferencing rooms and look at some seniors argue and take lessons from that. So it's opened up some opportunities for law students to learn various styles of advocacy and practice too, by sitting in their homes and logging on to the relevant courtrooms. But there's one thing, again, coming back to the downside, is that there are some people in the remote parts of the country, in villages, which are completely disconnected from the capital cities and more important cities. They've sort of suffered as well, because of courts not being open physically. Because for somebody who has a $500 claim against somebody, wants to recover that money, that person doesn't know how to do any filing, that person doesn't know how to do a video conferencing from where the person is. That person would normally go to the nearest court in the district physically and consult a lawyer there and file that case. But that's not happening anymore. So I think it's been a mixed sort of a year, but let's hope we are able to overcome these difficulties, because at the end of the day, what we do is not something that is dispensable. It's access to justice. Court should be open, court should be available, no matter what the nature of the problem is, or the pandemic is, because ultimately, if you're not getting somebody justice, if you're not getting somebody what's rightfully due to them, if you're not ensuring that people in jails are released and their bail applications are heard, despite the pandemic, we are doing a huge disservice to justice and to the rule of law.
And I think that's the perfect place to end on, I think. Very inspiring. I appreciate it. Before we do officially wrap up, is there anything else that you wanted to, any final message you want to give to our viewers and students who will be listening in from all across the world?
I think my message would be that law or the practice of law, and not just in India, across the world, is not Suits, is not Boston legal. It's not the over glamorized sort of depiction that you see on Netflix or someplace. It's actually reading. It's hard work. It's about reading a lot. It's about preparation. It's about the library. It's not Suits in that sense. And also, please have faith in the constitution. Please have faith in fundamental rights, and the basic documents that provide people freedom and protect liberties, because I think this is the reason many of us became lawyers for, right? To defend these liberties, to ensure that justice is done, to ensure that the state does not act arbitrarily, to protect freedoms. And I think that moral compass, or that motivation to become a lawyer, should not sort of dissipate in the profession somewhere. And that's going to be my message. Yeah.
Thank you so incredibly much for taking time today. A wonderful hour. We covered a lot of topics, and I'm really excited for people all around the world to hear everything you've had to say today. So I will go ahead and stop our recording.
Thank you so much.
Thank you.